When you hear the words living trust, do you automatically think of a tool that's only for the ultra-wealthy among us? Trusts are actually a common estate planning tool used by all kinds of people, not just those with millions of dollars in assets. Odds are good that, as a real estate professional, you will encounter transactions where the buyer or the seller is acting as a trustee on behalf of a trust, so it's important to have a basic understanding of trusts. Why are trusts used? Trusts can be used for many purposes. Let's explore some of the most common reasons. Number 1. When someone dies, a probate court proceeding may be necessary to clear title to real estate and other assets. Probate court can be expensive and time-consuming. In addition, when real estate has to go through probate court, state laws often impose lengthy restrictions on how and when that real estate can be sold. Creating a trust and making that trust the owner of real estate and other assets is one way to avoid the expense and hassle of probate court. Number 2. Another common reason for using trusts is to make sure that assets will pass according to your wishes after death. Trusts can be used to manage from beyond the grave, with assets managed and distributed years or even decades after the original owner's death. People whose children or other heirs have difficulty managing money may find comfort in being able to control distributions even after death through a trust. Number 3. Blended families often use trusts as an important part of their estate plans. Trusts can be used to ensure a current spouse will have assets they need during their lifetime, while making sure children from previous marriages are protected. Number 4. Tax planning is another common reason for using trusts. Through credit shelter or disclaimer provisions, people may be able to limit the amount of federal and state estate taxes due after their deaths. These are the most common reasons people create trusts. Some other reasons include providing for a beneficiary who has special needs without jeopardizing their ability for government assistance or leaving a charitable legacy. Understanding the parties involved in trusts. Sometimes the terminology of trusts can be confusing, but don't let the legalese confuse you. The person creating the trust is called the grantor, the truster, or the settlor. This may be an individual or a couple. People who inherit trust assets are referred to as the beneficiaries. As a real estate professional, you will likely come into contact with a trustee. The trustee is the person or company charged with managing the trust assets. The trustee is often the same person or people as the grantor. This is often the case when someone prepares a living trust to hold assets in order to avoid probate court. When real estate is inside of a trust, the owner will sign documents in their official capacity as trustee, rather than as an individual property owner. The trustee may be another family member or even a professional trust company or other professional fiduciary. The trust document itself will identify who has the authority to act as a trustee. Understanding different types of trusts. Just as there are many different reasons for creating trusts, you should also know that there are different types of trusts. Living trusts are trusts created by the grantor during his or her lifetime. After creating the trust, the grantor transfers ownership of some or all of their assets into the trust, to be managed according to the terms of the trust by the trustee. Testamentary trusts, on the other hand, are trusts that do not actually exist until the grantor dies. The terms of the trust, including who will serve as trustee, the identity of beneficiaries, and how the assets should be managed and distributed are all spelled out in the grantor's will, rather than in a separate trust agreement. Testamentary trusts are most commonly used when people want to provide for their minor children in the event of the parents' premature deaths. Understanding land trusts. As a real estate professional, you will likely also encounter land trusts at some point. A land trust is a specific type of living trust, specifically used to hold title to real estate for the benefit of someone else. People creating land trusts may want to safeguard their privacy and protect their real estate from liens, title claims, homeowners association claims, or other litigation. Putting it into practice. Now that we've explored what trusts are and how they work, let's look at an example of how you might encounter trusts when you're working as a real estate professional. Example number 1. John and Jane Doe want you to help them sell their house. When you review the property deed, you see that the house is owned by John Doe as trustee for the John Doe Living Trust under agreement dated January 1st, 2010. This tells you that John and Jane do not actually own the home as joint tenants or tenants in common. Instead, John established a living trust on January 1st, 2010 that owns the home. So, assuming John is not incapacitated, he will sign the purchase agreement and closing documents as trustee, rather than as an individual. In the event John is incapacitated, the trust agreement should specify who will serve as trustee in his stead. John's attorney can provide a certificate of trust to document who has legal authority to act, and whether or not there are any restrictions on that person's or company's actions as trustee. Example number 2. Sally Smith, a wealthy celebrity, created a land trust on the advice of her attorney to limit exposure and legal liability. Sally wants to buy a new mansion. Rather than dealing with Sally, you will instead be working with her trustee, a professional trust company, who will be the nominal buyer on behalf of Sally's land trust. You do not need to be an expert on trust law to be a successful real estate professional. But this introduction to how trusts work should help you when you encounter them in real life.